The justices of the Supreme Court of Ghana are not the type of employees that you can send a letter of dismissal to. This explanation, of course, is devoid of political influence and political interest, so you'll be assured that it is as the law requires.
It says that a justice of the Superior Court or a chairman of a regional tribunal shall not be removed from office.
What is the first ground? The first ground is that during such lunchtime, she has conversations about the case, how that she will give them a favorable judgment, should they bring a particular document and all of that. I mean, is it only a citizen who can present a petition for the removal of the Chief Justice? This state of the law is a bit problematic because sign to the petition or subscribe to the petition so that at least we'll have about 100 people, 200 people who subscribe to the fact that the petition be presented for a step to be taken. But if you want to remove the Chief Justice, you alone, Mr. President, we think that there's no problem facie case, therefore don't proceed further. The president can disagree with them and say, no, I think there's no facie case, I'm going to continue with the procedure. We'll not send a team from Make It Legal to go there and record the proceedings, because
if the Constitution explicitly states that where the petition is for the removal of...
I am Godwin Selassie Dapo, and this is Make It Legal. Make it legal. The justices of the Supreme Court of Ghana are not the type of employees that you can send a letter of dismissal to dismiss them from office, or you can send a letter terminating their employment to remove them from office. No, the Constitution has a exact procedure that must be followed if you ever want to remove any judge from the Supreme Court. In this video, we'll focus on the procedure for the removal of the Chief Justice of the Republic of Ghana as enshrined in Article 146 of the Constitution of Ghana. This procedure has been a subject of a lot of debate in the media as whether or not the president, upon receiving a petition for the removal of the Chief Justice, was mandated by law to forward same to the Chief Justice for her to respond to it before the president forward her response with the petition to the Council of State in order to make a determination whether or not there is a case being made against her for her removal. I mean, people have contributed and said a lot of things about what the right procedure should be, but in this video, I want to explain to you the step-by-step procedure involved in the removal of the Chief Justice of the Republic of Ghana. This explanation, of course, is devoid of political influence and political interest, so you'll be assured that it is as the law requires. It is not being done to score a political point or to meet the interest or desires of a political party. So if you are new to the channel, please consider subscribing to the channel, and as always, hit the like button to like the video, and be sure to share this video with someone. Let others get to know what we'll be sharing in this episode. What is important in the procedure for the removal of the Chief Justice from office is Article 146 of the 1992 Constitution of Ghana. So what does Article 146 say?
It says that a justice of the Superior Court or a chairman of a regional tribunal shall not be removed from office except for stated misbehavior or incompetence or on ground of inability to perform the functions of its office arising from infirmity of body or mind. 2 says that a justice of the Superior Court of Judicature or a chairman of a regional tribunal may only be removed in accordance with the procedure specified in this article. The president receives a petition for the removal of a Chief Justice of a Superior Court other than the Chief Justice, or for the removal of the chairman of a regional tribunal. He shall refer the petition to the Chief Justice, who shall determine whether there is a prima facie case or not. And 4 continues, it says that where the Chief Justice decides that there is a prima facie case, he shall set up a committee consisting of 3 justices of the Superior Courts or chairmen of the regional tribunals, or both, appointed by the Judicial Council, and 2 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers, and who shall be appointed by the Chief Justice on the advice of the Council of State. Now, 5 says that the committee appointed under Clause 4, which we just read, of this article shall investigate the complaints and shall make its recommendations to the Chief Justice, who shall forward them to the President. Where the petition is for the removal of the Chief Justice, the President shall act in consultation with the Council of State, appoint a committee consisting of 2 justices of the Supreme Court, one of whom shall be appointed chairman by the president. 3 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers. Continue to say the committee appointed under clause 6 of this article shall inquire into the petition and recommend to the president whether the Chief Justice ought to be removed from office. 8. All proceedings under this article shall be held in camera. Justice or chairman against whom the petition is made is entitled to be heard in his defense by himself or by a lawyer or other experts of his choice. And the president shall in each case act in accordance with the recommendations of the committee. And finally says that where a petition has been referred to the committee under this article, the president may, A, in the case of the Chief Justice, acting in accordance with the advice of the Council of State by warrant signed by him, suspend the Chief Justice. And B says that in the case of any other justice of a superior court or a chairman of a regional tribunal acting in accordance with the advice of the Judicial Council, suspend that justice or that chairman of a regional tribunal, and the president may at any time revoke a suspension under this article.
So you would observe that for a Chief Justice to be removed from office, there must be a number of steps to follow, and I'll take you through these steps. There are about 7 steps I've outlined. First and foremost step is that a person must allege that 3 major grounds exist which can necessitate the removal of the Chief Justice. So the allegation of grounds for the removal must be made. And these allegations must strictly speak to these 3 main areas, which when they occur, the Chief Justice can be removed from office, or the procedure for the removal can be triggered for her or for the Chief Justice to be removed from office. What is the first ground? The first ground is that the person must allege that the Chief Justice has conducted himself in a manner which can be referred to as misbehavior. Now, if she misbehaves, then she can be removed from office. What does misbehavior mean? I mean, it's a bad behavior which can put the office of the Chief Justice in disrepute. A conduct that we do not expect the Chief Justice of her caliber, of the kind of office she's occupying, to put up. If she puts up such a conduct, then grounds exist for the procedure to be triggered for her removal from office. So a misbehavior, that is how the law calls it. And what becomes a misbehavior will be looked at in the context of many factors. I mean, we do not expect the Chief Justice to be constantly seen in town getting drunk and holding bottles of akpetechi in her arms. We do not expect that of her. If she puts up such a conduct and it affects her work as a Chief Justice, then we could say that it is a misbehavior of a sort. We also do not expect her to sort of be going for lunch with parties who have case pending before her. She's having lunch with them, and during such lunchtime, she has conversations about the case, how that she will give them a favorable judgment, should they bring a particular document and all of that. I mean, she's not expected to do all of those. If she puts up conducts of that nature, then it's a misbehavior, which can be a basis to trigger the procedure for her removal. The second important thing, which Article 1461 talks about, is that he has been alleged or found to be incompetent. Incompetent is to be incapable of performing duties assigned to you by law or the obligations expected of the office you occupy. So if some allegations credible enough exist that the Chief Justice is incompetent in the performance of her duties, then there exists some basis to trigger the procedure. The third thing to note is that if there exists some evidence to point to the fact that she is unable to perform her duties because of infirmity of mind or of body, then there will be ground to start a procedure to remove her. An infirmity of body or mind talks about any physical bodily weakness or disease that could prevent her from performing the duties of her office. I mean, if she's insane, for example, I mean, she can obviously not be our Chief Justice with all the obligations she has to perform not being performed, and she'll be insane. Well, then that is an infirmity, and we cannot expect her to continue to be Chief Justice. So if these 3 grounds exist, then the second stage follows, which is that a petition must be prepared and sent to the President of the Republic of Ghana, alleging the grounds we talk about, either one of them. that they exist, and the Chief Justice should be removed from office because of the existence of those grounds. The law does not say much about a petition. It just says that a petition, what it means is that you don't need to file a writ at the court to seek to remove the Chief Justice. You don't need to make an application to any court for the removal of the Chief Justice. All you have to do is to prepare a petition, properly so called, for the removal of the Chief Justice. And of course, you have to attach relevant evidence to it that support the claims you are making, the grounds you are alleging that they exist for her removal. Now, the law does not also specify who can submit the petition to the president. Is it only a citizen who can present a petition for the removal of the Chief Justice? Should a person be a company? Should a person be a foreign entity? Should a person be just any person at all in society? Can a child present a petition for the removal of the Chief Justice? I mean, these are very important concerns which are not addressed by the Constitution. So what it means is that anybody who is in the jurisdiction of Ghana can present a petition to the president for removal of the Chief Justice from office. This state of the law is a bit problematic because what it means is that any and everybody from anywhere can get up, file a petition with the president that Chief Justice be removed from office. And Chief Justice, you know, is the head of the judiciary and occupies a very important place in our democracy. Being a democratic state which functions by 3 organs of government, the Chief Justice is a very important personality in the whole architecture of the democracy we practice. So if anybody can just get up and present a petition to remove her, there's a problem there. In a lot of other sectors where petitions are presented for things to be done, you will realize that people will be expected to sign to the petition or subscribe to the petition, so that at least we'll have about 100 people, 200 people who subscribe to the fact that the petition be presented for a step to be taken. But if you want to remove the Chief Justice, you alone can get up, write a nice letter in the format of a petition, attach your relevant document to it, send to the president. The president will begin to leave his busy schedule and begin to act on it. The third stage that follows after the petition is received by the president is the determination of prima facie case. Now, the president must be the one to determine that there exists a case for the Chief Justice to be called upon to answer before a committee. Now, it is not the president and the Council of State that makes the determination as to whether or not a prima facie case exists. It is the president alone, but he will do so in consultation with the Council of State. In other words, he will consult the Council of State before he makes such a decision whether or not there exists a prima facie case. Prima facie is a Latin phrase which simply means on the surface. So lawyers often use it to refer to a scenario where just by simply looking at the fact before you, could you form some basic understanding that something wrong has gone on somewhere? If that understanding can be formed just on the surface, then we say there's a prima facie case. So the president must determine that there is a prima facie case for the Chief Justice to be removed before the next stage you follow. You need to take a very close look at the provisions of Article 146 when you use the word in consultation with. In consultation with has been explained by our laws to mean that when the president refers the matter to Council of State and Council of State says that, Mr. President, we think that there's no prima facie case, therefore don't proceed further, the president can disagree with them and say, no, I think there's prima facie case, I'm going to continue with the procedure, because he's only consulting them. He's not mandated to, by all means, take and implement what the Council of State says to him. He can disagree with the Council of State for his own reasons and do otherwise. So he's only consulting them to make a decision. When we say act in accordance with advice of somebody or act in accordance with advice of the Council of State, whatever the Council of State says, you have to obey. You must obey. You must do as they say, even though it's an advice, in consultation with and in accordance with, as used in the Constitution. You'll get to see that. So the president, of course, is demanded to make the decision in consultation with the Council of State. The law did not mention anywhere that before he makes such a decision, he should inform the Chief Justice of what has been brought against her before he makes the determination of whether there is a prima facie case. That is not what the law says. The law simply says that he should make the determination once he consults Council of State. Now, you will also note that in Article 146, Clause 6 specifically, the word prima facie is missing there. And while you look at Article 146, again, Clause 3, the word prima facie is there. Of course, the case of Frank Ejechum and Attorney General has long explained that the Article 146, Clause 6 must be read with the understanding that prima facie case is deemed to be part of that clause. Of course, it's implied into it. So when we are removing the Chief Justice, we have to first of all find out whether or not there's a prima facie case before we form a committee to investigate the matter or to inquire into the matter. So that matter is settled, that Article 146, Clause 6 must be read with the word prima facie implied into its meaning. Once the president decides there is a prima facie case or there is a case somehow to be answered by the Chief Justice, then the president will now go to the next stage of the procedure for the removal, which is that the president is to form a committee of 5 persons. This committee is to consist of 2 Supreme Court judges. Of course, the Chief Justice cannot be part. 2 Supreme Court judges and 3 other persons who are not lawyers, who are not members of Parliament, and who are not members of the Council of State, who will inquire into the petition and find out whether or not the prima facie case that is made for the removal of the Chief Justice is true. When we now hear from the Chief Justice, her own response, her own evidence, and all of that. So it is at that committee hearing that the Chief Justice will be notified that a case has been made on the surface that you should be brought to a committee to answer why you should not be removed from office. And the Chief Justice will come there, of course, with her lawyer or any expert that she prefers, depending on the matters at stake. The commission's work is simple. They inquire into the petition and make a recommendation. Very important. They must recommend that, yes, we think that CJ must be removed from office. What we have seen with our eyes and heard with our ears is too much. She should be removed from office. Or they can say that, no, she must stay in office. So they must make a recommendation to the president. That is part of their job. And all of these things must be done in camera. In camera simply means that in secret and confidential. Nobody should go taking camera there to record it. We'll not send a team from Make It Legal to go there and record the proceedings because it's going to be in camera. That is what it is. Of course, the judges can record it with their pen in their books and all of that. And they can even be recorded on a device for purposes of getting it transcribed. But it must be in camera. No party will be invited into the room if that party has no role to play there. And if you have a role to play there too, you have to ensure that the proceedings are kept in secret. Next important stage after the committee is just about to begin their work is that the CJ must be suspended from office. The president must suspend the CJ. She will no longer be a CJ until the matter is determined by the committee and the recommendation is made. So in her absence, obviously, the most senior justice of the Supreme Court will be acting as a CJ until she's back or she's gone and a new one is finally appointed. Of course, the suspension can always be revoked by the president. I mean, he's the one going to suspend the Chief Justice, and he can at any time decide that, you know what, I think for ABCD reason, your suspension should be revoked. Get back to office and all of that. That is a possibility. The last and most important stage of the whole process is the removal of the Chief Justice. So once the committee recommends that he should be removed, the president must act in accordance with the advice. The president must just proceed to remove her without saying that, well, I've seen the committee's report, their recommendation that I should remove her, I've seen it, but I think that in my wisdom, that recommendation is not sound, therefore I'll not comply. No, the president cannot do that. He must act in accordance with the recommendation. So the president will have to communicate the decision to the Chief Justice as to what the recommendation is. And whatever recommendation it is, if the recommendation is for her removal, she will be removed from office. Now, a lot of people have been questioning what has been happening so far. And one respected lawyer who's quoted your story has asked a number of questions, which I think is important. Now, what are the questions that he's been asking?
If the Constitution explicitly states that where the petition is for the removal of the Chief Justice, the President shall act in consultation with the Council of State, is it unconstitutional for the President to refer the petitions to the Council of State? Also continues to ask, should the President unilaterally decide on the petitions without engaging the Council of State as mandated? Does referring the petitions to the Council of State amount to a prima facie determination without giving the Chief Justice a hearing? Does his referral prevent the Chief Justice from later providing her comments on the petitions?
I think these questions are important. So if you ask me, the president has no obligation of law to forward the petition to the Chief Justice for the Chief Justice to comment or respond to it. Then the president will take the response from the Chief Justice or the comment from the Chief Justice and forward it to the Council of State with the petition. That is not in accordance with the Constitution. So, I mean, because the matter is before the Supreme Court for determination, I wouldn't comment any further. But my opinion is that it is not a constitutional requirement that the president is supposed to forward the petition to the Chief Justice for a response before the president carries on with the next step. That would be my opinion, and I'm glad to express it. If you enjoyed this video, do us a favor by subscribing to the channel. And if you had to like this video, go ahead and like the video and click on the share button to share with someone. I am Godwin Selassie Dapo, and this is Make It Legal. Make it legal.